Okay. So did we have somebody else join? Nope. Okay, great. So the court will call cause number P8133 in the matter of the estate of Phyllis Maudine Sanders. Housekeeping and order of events this morning is what I'd like to discuss first. And for all of our beneficiaries and uh, hopeful executor slash executrixes, if y'all would just hang tight for a few minutes while Ms. Forsyth, Mr. Schwartz, and I get lined out on how we're going to proceed and what is being requested of the court this morning. Let me just start off by saying, as I understand it, there was an initial application filed in which the initial application sought the appointment of Miss Sanders Alvarado as the executrix of the estate. And at some point in time between the filing of that application and the next conduct that occurred in the case, there was a change of or a shift in counsel. Ms. Alvarado retained Mr. Schwartz. Ms. Forsyth pivoted to Mr. Obrero and the beneficiaries. And Mr. Schwartz is seeking to move forward on the application to appoint Ms. Sanders Alvarado as the independent executrix of the estate. And Ms. Forsyth, my apologies, ma'am. Ms. Forsyth is seeking to have Ms. Sanders Alvarado removed as executrix and appoint as independent executor by agreement of all beneficiaries of the estate, Mr. Michael Obrero. Is that a correct summation?
Do you have one clarification? I've never spoken with Miss Sanders Alvarado. She was never my client. We've always represented Paula Obrero and additionally the beneficiaries. Mr. Schwartz, do you have another clarification as well?
Yes, and Judge, may I also note that Paula Obrero is the initial applicant here. She filed for probate of will, seeking to have my client, Crystal Sanders, appointed as the independent executor of this estate, which by law she's entitled to do as an interested party.
I understand. I apologize, and I see
problem.
It's right on the first page. If Miss Forsyth, you filed your application on behalf of your client, Paula Obrero, and as I do understand that, and my recitation was factually untrue. So thank you for clarifying. Are there any other clarifications before I go to step 2?
Yeah.
I think that's it for housekeeping, Judge.
Okay, thank you. So, and I would appreciate any insight or guidance that either of y'all, as the attorneys, would like to provide to the court. In my rudimentary understanding of probate, we can't remove an executor that's never been appointed. And it would seem to me that if y'all agree, the process of going through the initial application and then hearing the removal application is probably the cleanest. But if y'all want to agree to proceed in a different manner as dueling applications, I guess I'd be happy to consider that as well. Yes, please, Mr.
Your Honor, I was going to say, what we have here, obviously, like you stated, is an application to remove Ms. Sanders, who has never been appointed. This Texas Estates Code is very clear in terms of removing executors in naming by agreement executors or administrators. 401.002B of the Texas Estates Code deals with appointing administrators by agreement. And that comes into play, Your Honor, when there's an executor named, but the named executor is deceased, is disqualified by law for some reason, or has declined to serve. That is the only place in the Texas Estates Code that gives beneficiaries the power to name a personal representative of an estate. Otherwise, what they're essentially trying to do is change a provision of a will, which I'm not sure in law, there's no case law to support changing a provision in the will or setting aside any specific provision in favor of another. So our concern is obviously applicant filed the application for probate. They moved forward with that. And in their application, they stated that Crystal Sanders is qualified and not disqualified by law from serving as the executor of this estate. And she, in fact, is qualified, Judge, and is not disqualified. There was nothing in their motion to remove that would disqualify my client from serving. It is the testator's intent in drafting the will and appointing my client as the independent executor for her to serve in said capacity. And what they're attempting to do is to phase out Crystal based on conflict of personalities and trying to get someone else appointed, essentially ignoring the testatrix intent as it pertains to the personal representative of this estate.
Thank you, Mr. Schwartz. Ms. Forsyth, do you have a response?
Yes, so it's my understanding from my clients that prior to Miss Sanders passing, she did not want Miss Alvarado to be the executor, and that while there is a personality conflict, I will admit there's some personality conflict. I think there's the best interest of the estate is to switch out the executor, especially since my understanding is, Mr. Schwartz, you can correct me on this, your client does not live in the state of Texas, is that correct?
Yes, that is correct, but that does not disqualify her. She has appointed a resident agent to receive service of process on her behalf as required by the Texas Estates Code. So the fact that she lives out of state does not in any way disqualify her from serving.
I understand your point. Like I said, that's just where we're at right now, and there's been no movement on her part to probate the will or to begin dispersing Ms. Sanders' assets either. And that's why Ms. Abrero went ahead and filed the application. And we're just seeking to have somebody in town that's able to do all that.
Judge, may I add something to that? I'm sorry, I didn't mean to interrupt.
Ms.
Ms. Forsyth, were you finished? My apologies. I did not mean to interrupt you.
No, it's okay. Go ahead.
Okay, what I was going to say, Your Honor, please note that the decedent passed away on December 6, 2020. And the application for probate was filed January 28th, which is approximately 2 months after her passing. Obviously, under the statute, there's a 4-year window for probating the will. And in addition to that, Judge, the applicant, Ms. Abrero, who's a beneficiary under the estate, was well within her right to do what she did as far as filing for probate. There was no contact made, as far as I know, with my client about moving forward fast with probate. Whether that's true or not, I don't know, but not to my knowledge. But That is cured by Ms. Abreu filing her application to probate on January 28th. And in her application, Judge, she requests that our client be appointed. She states that my client is not disqualified by law from accepting letters testamentary or serving as the independent executor of this estate. And she states that this will was never revoked. No provision of the will was never revoked, and they're moving forward with probating the will, which, okay, they have that right to do. But what they're now trying to do is to nullify a clear provision of the will that appoints Ms. Sanders as the independent executor by agreement. But there's nothing in statute or unless Ms. Forsyth can explain or cite any case law that gives Ms. Obrero the right to now by agreement, or the other beneficiaries by agreement, to basically oust or thwart my client's appointment as the independent executor of the estate. And we've been practicing probate exclusively now for a number of years. This is the first time I've seen this, and I've researched the law extensively, have not come up with anything that remotely deals with this specific issue. The closest thing that I've dealt with dealing with by agreement naming of a personal representative is statute 401.002B of the Texas Estates Code that gives the distributees and beneficiaries of a will the authority to name an alternate in the event that the named person is deceased, is disqualified by law, or signs a declination to serve and files that declination with the court. We're of the opinion that Ms. Sanders has no fiduciary duty as it stands today. She has not been appointed as the independent executor of this estate. No letters testamentary have been issued to her. You have not appointed her, Judge. So they're all on equal footing as it stands right now. There is no fiduciary duty owed to anyone. They made demands for my client to make an accounting, which we have included one of the emails as part of our response to their motion to have her removed. So we're just looking to move forward, Judge. We're looking. My client is here. She's legally capable, not disqualified. She's here to take her oath and start the process of administering this estate.
Ms. Forsyth, would you like to respond briefly?
Yes, sorry, that was quite a
Okay.
big thing. Give me a second to collect my thoughts. So actually, if Miss Crystal Sanders Alvarado had indeed breached her fiduciary duty, then yes, she can be removed as executor. She has called the police and failed to allow the heirs to enter the home. She has no interest in the home other than being executor or named executor, and she's called the police and not allowed them to enter the home or be a part of the home. She's also she also called the police. When she called the police, she let the police know that it was her home, which is not the case. The home was not left to her.
I object to that, Judge. We don't have the police here to testify to that fact. So
it's in the report.
We're going to object.
It's in the report.
I'm going to overrule Mr. Schwartz. I'm very comfortable and familiar, and I appreciate it. I'm just trying to, and I want Ms. Forsyth to have the opportunity to. I'll let you go. It's okay. And then I think I know the way that we're going to proceed this morning. So, but I don't want to cut this off because I think it's important that I give both of y'all an opportunity to just in general kind of talk about how we got to where we are this morning.
Sorry about that.
It's okay. Please continue.
Thank you, Judge. So that's kind of where we were with that. We're all we want is for Ms. Obrero and the rest of the beneficiaries to have the home and have access to the properties, to be able to basically just go through what the request of the decedent was. And the bank accounts as well. Yeah, that's pretty much where we're at, Judge. That's just kind of the short of it, if you will.
Yes, ma'am. Thank you. And I'm sorry for all of my movement while you were speaking. My laptop was at 5%, so I would have hated to disappear from y'all. Okay. One last question. Miss Crystal Sanders Alvarado she's not a beneficiary.
No, Judge, she's not a beneficiary.
One of her parents is still alive and inherits. Is that
Well,
how it goes?
Paula is her mother. The applicant is her mother.
Okay. Okay. So this is what we're going to do. We'll proceed on the initial application, and I'll allow Mr. Schwartz to seek to prove up the probate, and then at the conclusion of that hearing, we can take up the motion to remove and to appoint the alternate executor by agreement. Is that okay with both of y'all, Mr. Schwartz, Ms. Forsyth?
Sure.
Okay, then let's go ahead. Mr. Schwartz, what witnesses will you have for this component?
I have the named executor, Crystal Sanders Alvarado.
Ms. Sanders Alvarado, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to provide in this proceeding is the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. Mr. Schwartz, you may proceed.
Okay, please state your name for the court.
Crystal Sanders.
And Ms. Sanders, is it true that your grandmother, Phyllis Mardine Sanders, died on December 6, 2020 at the age of 82 years?
Yes, it is.
Is it also true that she was a resident of B County on the time she passed away?
Yes, that's true.
And you've seen a copy of the will that has been provided to the court for probate, is that correct?
I have.
The date of the will is June 8th, 2006.
Yes, that's correct.
And that will was properly executed by the decedent, is that correct?
Yes.
And that will was never revoked, as far as you know, is that correct?
No.
And 4 years has not elapsed since the date of your grandmother's death, is that true? Okay, and the will names you to serve, sorry, I'm going ahead of it. The will names your grandfather, Paul Dean Sanders, to serve as the independent executor of this estate, is that correct?
Yes,
But he's deceased, is that right?
that is correct.
The will then names Anthony Wayne Sanders to serve as the first alternate executor, independent executor of this estate, but he's also deceased, is that correct?
That is correct.
And then the will names you to serve as the second alternate independent executor of this estate to serve without bond, is that correct?
That is correct.
And you are in fact qualified and not disqualified by law from accepting those letters, is that correct?
That is correct.
And as far as you know, after the date that your grandmother created her will, there was no marriage dissolved by her, is that correct?
That is correct.
And there were no additional children born to or adopted by her after the date that she created this will, is that correct?
That is correct.
And this will does not name the state of Texas or any charitable organization as a beneficiary. Is that correct?
That is correct. It does not.
Oh, okay. Nothing further, Your Honor. We just ask that the will be admitted to probate and Crystal Sanders Alvarado be appointed as the independent executor of this estate pursuant to the terms of the will.
Thank you, Mr. Schwartz. Ms. Forsyth, do you have any questions of the witness? And I'd ask you to limit them to this application. I understand you have your removal, but.
Yeah, I have my request on file and the motion to remove her, but other than that, I don't have any questions for her.
Okay, thank you. I find the evidence in due form. One question I would have, Mr. Schwartz, did you file a resident agent designation?
Yes.
Okay.
Yes.
Thought I'd seen it in the file somewhere, but.
Yes, I do. It is on file, Judge, but I can, I don't know if I can email it. I do have a stamped copy that it was accepted.
No, it'll be here.
Okay.
The court will take judicial notice that I do have the original will in the file. Ms. Sanders Alvarado, have you been convicted of any felonies or crimes of moral turpitude, theft,
No, Your
embezzlement?
Honor.
Okay. Then the court will admit the will of Phyllis Maudine Sanders to probate. The court will authorize letters testamentary to issue to Crystal Sanders Alvarado. And I have orders in front of me. Let me take a look at them real quick. That's on the other hearing. That's on the other hearing. That is Ms. Forsyth, Ms. Forsyth. Okay. One moment, let me review the proposed order. Okay, that order admitting the will to probate and authorizing letters testamentary to Crystal Sanders Alvarado has been entered. At the conclusion of today's hearings, provided that circumstances do not change during the remainder of this Zoom call, Mr. Schwartz, how many copies of letters testamentary will you need upon Ms. Sanders Alvarado executing an oath of office and due form and it being filed in my clerk's file?
5, Judge.
Okay. Okay, so Ms. Sanders Alvarado, you have been appointed as the independent executrix of this estate, but your appointment does not become complete and active until you've executed an oath of office, which is a necessary component in Texas law. And I don't know logistically, Mr. Schwartz, what your plans are for completing that. We're very flexible down here.
Yeah, well, Governor Abbott has instituted the online notary provision right now. So we're going to have her execute her documents in the presence of a notary online, get a copy, then file it with the court.
Okay. Do you expect that'll be today?
Yes, yes, it'll be today. It'll be today.
Do you have, or Ms. Forsyth, do either of y'all have any objection to the court proceeding on the motion to remove Ms. Sanders Alvarado at this time, even though she's not, under the law of the state of Texas, she's not the executrix yet because she hasn't executed her oath of office?
I have no objection, Judge.
Ms. Forsyth?
No, Your Honor.
Okay. All right. So, Ms. Forsyth, you have filed a motion to remove, motion to remove executor and appoint agreed upon independent executor of the estate. Will you have witnesses this morning, or will it all be by argument only?
My plan is argument only, but we do have witnesses available if you would like to speak with anybody about that time, Judge.
Okay, well, I guess what we can do, again, unless Mr. Schwartz, I don't want to necessarily put get everybody under oath unless they're actually going to provide substantive testimony. If we have just a simple question, then I'll probably let it go. Unless y'all object, please let me know. And to the other individuals, beneficiaries, proposed successor, executor, or executrix, if you would, please be mindful of the fact that you are not under oath. And so anything that you say when you're not under oath, the court does not need to consider, right? So your answers only matter once you have taken the oath. And so I can swear all of y'all in right now, or we can just play by ear. And if I need to swear y'all in down the road, I can. It only takes a moment. Do y'all have a preference, counselors?
Let's just go ahead and swear everybody in. It's quick.
Okay.
It's easy. Let's go for it.
Everybody else, please raise your right hand. Do each of y'all solemnly swear or affirm that the testimony you may provide in today's hearing is the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Yes.
Great, thank you. Ms. Forsyth, you may proceed.
Okay, Your Honor. So today we request that we remove the current executor or the intended executor from the will and move it over to, I apologize, Your Honor, Michael Obrero, who is the son and does not take under the will of Paula Obrero, our applicant. The reason being is I know Mr. Schwartz mentioned that there's no case law regarding removal of executor. However, there is one for gross misconduct or gross mismanagement, which includes a 3-prong option: any willful omission to perform a legal duty, any intentional commission of a wrongful act, or any breach of fiduciary duty that results in actual harm to beneficiary interest. So on that point, my first point is any willful omission to perform a legal duty. Yes, I understand that she has 4 years to admit the will to probate. However, we here, before we were aware that Ms. Sanders Alvarado was represented by counsel, did contact her on 2 occasions and offered to be of assistance for her. We never received a reply from that, but we did offer. Once we knew she was represented by counsel, we ended that communication. She's also breached her fiduciary duty, as she's not given any information or an accounting or an understanding of what Ms. Saunders owned at the time of her death and anything current. The only thing we're aware of is there are bank accounts and then the home, which the home has been quite contested about who can live there. And like I said, we have the police report that says the police were called to the location to stop anybody from entering the home of Ms. Sanders, which is rightfully belonging to the beneficiaries we discussed. So that's kind of just a brief overview of what we're seeking. We picked Mr. Paula Obrero's son, Mr. Obrero, to fulfill fiduciary, the duty of executor, because he is located there. He's able to do everything necessary for the estate and was chosen by all of the beneficiaries.
Ms. Forsyth, under what authority are you alleging that fiduciary duties exist prior to a few moments ago with respect to Ms. Sanders Alvarado?
That is an excellent question, Your Honor. And it's my understanding that it's the fiduciary duty doesn't start until then, but she also didn't have the right to keep the beneficiaries from the home and from any item there. Just 1 second to grab something up in my documents. 1 moment, please. Also, Judge, I'd like to open up that she's already started spending the funds out of the local agent, which is not necessary in this case. Like I said, we have people available here in Texas to take care of those duties. And also, there is evidence of misconduct and mismanagement. And I understand that an acts of self-dealing prior to the will being admitted to probate. However, I feel that in this case, that just reflects on how it will go in the future as well. And we need somebody in this position that's going to be able to deal with everybody and execute the will as named.
Ms. Forsyth, the court would appreciate some testimony with respect to the various allegations that you've made.
Sure.
Live testimony. I know that the court does take judicial notice of the several affidavits that have been filed and has reviewed them, but
Okay.
I'd hear it live if you don't mind.
Okay. Let's do Brittany first. Give me just a second to pull up my questions for Miss Brittany. Okay, Miss Brittany, you've already been sworn in before the court, so you understand what you say must be the truth, the whole truth, correct?
Yes, ma'am.
Okay. Can you, okay, prior to your grandmother's death, did your grandmother say anything about Miss Crystal becoming executor of her will?
Yeah, she told me that her and Crystal had not been getting along, that Crystal had been fighting with her, and that she wanted to tear up her will because of that reason.
Are you aware of why they were fighting?
She didn't get into much detail, just that Crystal had said we were keeping her from her Mexican heritage or something like that. By putting her through college, my grandmother had bribed her. Just had her really upset that my cousin didn't call her for her birthday. She just made it known that they were not getting along.
Okay, thank you. Were you present at any of these, any conversations between your grandmother and Miss Crystal?
The last one, when I was there, I brought my baby down to visit my grandmother. Crystal had called. They got into it on the phone. My grandmother was saying she wasn't going to apologize for something. I didn't hear the depth of the conversation. It was very brief.
Did your grandmother ever say who she would have preferred to be executor or who she wanted to take care of her affairs?
No, she just said she wanted us to tear up the will.
Okay. Have you had any interactions with Miss Crystal since the passing of your grandmother?
Nope. She blocked me on Facebook, blocked me on all social media. She has not spoken to me at all.
Okay. Do you know the reason? Did you guys have a fight before the decedent's death or after the decedent's death that caused between the two of you?
Crystal called me out of the blue, contacted me out of the blue, saying that because we were white, we were racist, that our family was white supremacists, that we kept her from her heritage. I asked her, when did she start playing a victim? Because that's never been her. You know, I've always looked up to her. Always. Like, I've flown out to California to see her. And she just, all of a sudden, we were like the enemy. We were racist, white supremacists, and she's blocked me on everything. She called my fiance a misogynist pig, you know, and I really don't understand what happened, because she was supposed to be coming to visit me a few months before. So I don't really understand where all this came from.
Okay. We'll go to, that's all the questions I have for Ms. Brittany at this time. Mr. Schwartz, do you have any questions?
I don't have any questions.
Okay. Your Honor.
Yeah, Brittany. I don't have any questions either. Ms. Forsyth, do you have any other witnesses?
Yes, Ms. Obrero, Paula Obrero.
Ms. Obrera, you're on the virtual stand. Please proceed, Ms. Forsyth.
Yes, I'm sorry, Judge. I have trouble hearing. That's why I'm leaning forward. I'm trying to hear.
Perfectly fine. Hey, everybody on this call is doing great. The previous probate hearing, we had to bring them actually physically to the courthouse because their Zoom wasn't working. So y'all are all getting gold stars today. Please proceed.
Thank you, Your Honor. All right, Ms. Paula, you understand you're under oath, and anything you say before the judge is under oath, and you swear to tell the truth, the whole truth. Do you understand?
Yes.
Okay, can you state your name for the record, please?
Paula Deanna Obrero.
And how are you related to the decedent, Ms. Sanders?
She's my mother.
Okay. And can you tell me have you had any interaction with Miss Crystal since the passing of your mother?
Yes, she's communicated through my son to me. I haven't actually spoken to her for over 10 years. She's been going to my son for things, and we've sent her the copies of the will and, anything she's asked for up until she started insisted on having the title to the house and the car, and made some comment that my mother wanted her to be in charge of, my mother wanted the house put in her name, and that was never, ever an intention of my mother.
That's okay, Ms. Paula. That's all I wanted to know for you. I can ask your son about some of the interaction he's had lately with Miss Obrero, or with Miss Crystal, if that's okay with you.
I didn't hear what she said.
Ask any questions.
Oh, okay.
Okay.
Judge, may I ask a few questions for Ms. Obrero, the applicant? Hello, Ms. Obrero. I just had a few questions with you. You filed an application to probate this will, is that correct?
Yes.
And in the will, you stated that as far as you know, the will had not been revoked. Is that correct?
Yes.
And so you're okay with the will and you're not contesting the will in any regard. Is that correct?
The only question we're having is Crystal as executor, because she's been extremely
Difficult.
Yeah.
Okay.
She's been really difficult. We can't get any information from her.
Mm-hmm.
We don't know anything about what upkeep is going on the house, what she's done as far as any of the executor stuff that we've been allowing her to do, and we just can't get any information from her. And the basic information we were needing to know, we haven't been able to ask.
Right. So I guess it's safe to say that in filing this motion, you're good with the will. You're just seeking to set aside the provision that names Crystal as the independent executor. Is that correct?
Yes.
Okay. Nothing further for this witness, Judge.
Thank you, Mr. Schwartz. Ms. Forsyth, do you have any redirect?
Yes, just to be clear, Miss Obrero, I'm gonna try and speak up. So if I get loud for everybody, I apologize. So Miss Paula, you originally were okay with Miss Crystal being the executor when we first talked. Is that correct?
We weren't okay because my mother specifically on their last conversation, I was also present with Brittany, and my mother was in tears when she got the phone call, that last phone call, and she did state that she wanted the will to be torn up. So that's the only problem we had with Crystal at that time.
And that was only because of Crystal, right? Not the actual will itself, just for Crystal being the executor? Or were there other parts of the will that she was unhappy about?
It's just that her being executor and just what she had gone through in the state she was in after the phone call.
Okay. And originally, as long as Miss Crystal was agreeable and willing to work with us, you were okay with her being executor. Is that correct?
Yeah, we were okay with trying that.
Okay.
We weren't sure how it would go because she doesn't communicate with us, especially me.
Okay.
Can I ask a question?
Are you done, Ms. Forsyth?
Yes, go ahead.
Recross.
Yes, Ms. Obrero. So just again, we're going to revisit this one more time. You're saying that your mother discussed revoking the will, but there was no, because you filed an application stating that the will was never revoked. So your mother talked about revoking the will, but never revoked. Is that correct?
Right. She was
Okay.
there at the end. She was pretty much physically incapable of doing any kind of expenditure of her energy, and everything made her very nervous. So she wasn't able to actually tear up the will herself. She couldn't go locate it, anything like that. And we didn't feel like after the fact, since the will was still as it was, we didn't feel like we could do anything at that time about the way the will was written and stuff. We just knew her intentions after the phone call, and that was where we stood with that.
So just so we're clear, and so the judge is clear on this issue, and so the record is clear on this issue, you're not claiming that your mother actually revoked this will. Is that correct?
She just told us that she did not want Crystal as executor, but she couldn't physically or mentally do. She wasn't confused or anything. She just, her emotional state after these phone calls, she couldn't get out anywhere to go get a lawyer. We couldn't do any of that kind of stuff with her. We just know what happened with the phone call when Brittany and I were present.
Right. So is it your testimony that no, your mother did not revoke the will?
Other than to tell us that she didn't want Crystal as executor, no.
Okay, so
there was nothing else in the will that.
So if we can just focus on the will. Let's not focus on any other provision. Let's just talk about the will. Did your mother revoke the will?
No.
She said no.
No. Okay. And so in filing this application to remove, you are just seeking to set aside the provision that appoints Crystal. Is that correct? Everything else is good with the will. You're just seeking to set aside the provision that names Crystal as the executor of the will. Is that accurate?
Yes.
Okay. Nothing further for this witness, Your Honor.
Thank you, Mr. Schwartz. Ms. Forsyth, any redirect?
I just want to clarify, it's not a motion to set aside Crystal, it's to remove her entirely from it,
Okay.
since we've already,
I'm sorry, counsel. So you're saying this is a proceeding to remove Crystal altogether?
yes.
Okay.
Yes.
Okay. Judge, can I call Brittany back? And I just want to clarify. I want to ask her the same question.
Not yet. Ms.
Okay.
Forsyth,
Okay.
yeah.
I'm sorry.
yeah,
Okay.
you'll have a chance. Ms. Forsyth, do you have any other witnesses?
Yes, I wanted to talk to Michael.
Okay. Mr.
All right. Michael, can you please state your name for the court?
Michael Paul O'Burrow.
And you understand that you've been sworn in and you're going to tell the whole truth and nothing but the truth, correct?
Correct.
Okay. Can you tell me about the incident after your grandmother's death in Beeville?
With the police.
Yes. What were you guys doing at the property?
So we pay a gentleman every month to keep the yard maintained and to feed my grandmother's cats. And an officer came up saying that that they got called for trespassing or somebody trespassing on the property. And or he called me saying that's what happened, and the officer took his statement saying that he was just there to feed the cats and take care of the yard. I went up to the police station and spoke to the officer that came by, and he said that they had gotten a call from Crystal saying that she was the owner of the house and that nobody was supposed to be living there or nobody was supposed to be there.
And why did the officer know why no one was supposed to be there?
He just got a statement that the owner called and said that there might be somebody trespassing on the property, and they went by to go check.
Okay, did they give you a name?
Crystal Sanders.
And
was
to your
on the-
knowledge, the
Sorry?
property does not belong to Crystal, is that correct?
Correct. It does not belong to her.
Okay. Okay. And just, let's see. So, yeah, that's all for this witness, Your Honor.
Mr. Schwartz, you have any cross-examination?
No, Judge, I do not have any cross for Mr. Abreu.
Thank you, Mr. Abreu. Ms. Forsyth, do you have any other witnesses you'd like to call?
So I guess we'll bring back Miss Brittany,
Okay.
just because Mr. Schwartz asked, so we'll do
Ms.
that.
Brittany, you're still
Thank
under,
you.
Ms. Forsyth, you may proceed.
Thank you. So you're still under oath. And Ms. Brittany, so you guys don't contest the validity of the will itself. Is that correct?
No, not the will itself.
The testimony you were giving for about the will being your grandmother wanting to tear up the will was just an example of her relationship before her death with Miss Crystal. Is that correct?
Correct. She knew it would be difficult.
Okay. Mr. Schwartz, do you have any questions?
Okay, thank you, Ms. Brittany, for clearing that up. So again, just so we're clear, you're not contesting or you're not stating that your grandmother revoked this will.
No, she didn't revoke the will. She was worried about Crystal.
Okay. So in giving your testimony today and filing your affidavit, you're not contesting the will. You're just wanting to set aside the provision which names Crystal as the executor. You don't want Crystal to serve as the executor. Is that correct?
Remove Crystal as executive.
Remove Crystal as the executor.
I feel she would not have our best interests at heart at this time.
Okay. But in the will names Crystal as the executor. Is that correct?
All right.
So, but today you're trying to set aside that provision. Is that correct?
Remove that.
Basically, well, so set aside, when I say set aside, I mean that provision is not going to be enforced. So you're
Right.
looking to set aside that provision that names her as the executor. Is that correct?
Right.
Okay. Nothing further, Judge.
Thank you, Mr. Schwartz. Ms. Forsyth, any redirect?
No, Your Honor,
Do you have any other witness, Ms. Forsyth?
not at this time.
You want to reserve any closing arguments for the very end? Do you want to
Yes, I would, please.
Okay, Mr. Schwartz, would you like to call any witnesses?
I will call Miss Crystal Sanders.
Okay, Ms. Sanders, you're still sworn in. Mr. Schwartz, you may proceed.
Okay. Miss Sanders, were there any accounts of the decedent that you were listed as a joint owner?
Yes, her main bank account.
Okay, on her main bank account, you were the joint owner and beneficiary of that account?
That is correct.
Okay. That's all I have for Your Honor. You know what? Let's talk about the phone call because you were notifying law enforcement of an apparent trespasser. Can you explain to the court that call and the purpose for that call?
Yes, definitely. I have still lots of people I consider family, and maybe not blood relatives, but family and friends in Beeville, and they're aware that my grandmother passed, and were driving by and just making sure the house was okay, and they noticed people doing construction. The toilet was removed from the house and set outside on the driveway, and there has been I made clear when I called the police in the phone call that I was not the owner, that my grandmother passed away. This was the house was property of her estate, and that nobody should be in the house doing construction because none of that was authorized, because the house was yet to go through the probate process to be delivered to the beneficiaries. And so I didn't know who was there. It was cars that I didn't know. My friend sent me a picture and I didn't know whose car it was. And so in concern of keeping my grandmother's estate and the property in the best interest, I asked the police to drive by and see what was happening.
Okay. And at that time, you had not been appointed as the executor of the estate, correct?
That is correct.
However, as the named executor, you were just being proactive in terms of following up on leads about work being done at the house and persons that you weren't aware of or had no knowledge of being at the house. Is that correct?
That is correct.
Okay. Nothing further for Ms. Alvarado. Judge.
Mr. Schwartz, Ms. Forsyth, do you have any cross-examination?
Yes, I do. So is the house in need of any repairs that you're aware of?
I knew from talking with my when he called me to notify that my grandmother had passed several days after she passed, and asking to what needed done. And he said that she had been having trouble with the plumbing, and that needed, because I was inquiring because I was trying to make it to the funeral, but they failed to inform me that she had passed until several days after her passing and had already scheduled the funeral. And I'm in San Francisco, and given the conditions with COVID and the pandemic, obviously considerations on travel and how to get there, I would have had to drive, and asked about if I should stay at my grandmother's house or if I should get a hotel room. And his response was that the plumbing was acting up while she was alive, and they hadn't fixed it, and that it was probably best for me to get a hotel room. And I also, because of the pandemic, expressed concern. I had recently had surgery, and so for protecting immune systems and preventing spread of COVID, was trying to identify if people would be needing to come in and out of the house at the services if I were to make it there. And if that was the case, then I was going to choose to have a hotel room so that we could limit exposure for COVID in that case. But it's the only repair that I had known of in that context of me potentially traveling there for the funeral.
Okay, so the house has been vacant since your grandmother passed away, correct?
As far as I can tell, yes. As far as I know.
Okay.
I've seen, other than them going in and, or whoever was doing construction and removing toilets and
Okay,
things.
are you opposed to them making repairs and maintaining the property?
They are not authorized to do so. It's still in my grandmother's name. They are not named on the title of the house, and they are simply just unauthorized.
Since they're unauthorized, who would you authorize to be able to look at the house, do repairs, and maintain it, including feeding the cats?
It isn't one that was never an option that was asked of me. And also the repairs were needed when my grandmother was alive, and there was no urgency in that moment to repair the sewage. And since nobody was living in the house, I also still do not see an urgency to repair the sewage.
Okay, so you don't feel.
And I would hire a qualified professional if those things are needed.
Okay, well, the property, are you arguing that the property doesn't need to be maintained? Well, no one's there, because that would be.
That's not what I'm arguing at all.
Okay, can you elaborate, please, on what you're trying to say? So you don't want them on the property, correct? Even though they are. Is that correct?
I did not say that.
Well, please elaborate. What it sounded like that you were saying you didn't want them on the property because they weren't authorized.
I did not know who was on the property.
Okay.
I don't know who was on the property. And there was unknown vehicles on the property. And there was obviously some demolition involved because there was a toilet sitting out on the driveway for several days, if not weeks. And so my concern was that they were them or other people who may have been in the house were not acting in the best interest of my grandmother's wishes for her estate. And nobody had ownership at that time. And there's a difference between feeding the cats and mowing the lawn and doing construction work that involves removing toilets and larger things that are unnecessary if nobody is living in the house.
So, let me think of how to phrase this. Give me just a second. So Ms. Crystal, did you ever have any intentions of doing rehab to the house or taking care of it yourself?
Once I was appointed as executor through the court, and once I could get there, again, we're in the middle of a pandemic, so I didn't want to just travel there. I also had health concerns about traveling, but it was absolutely my intent to ensure. I asked my brother Michael on several occasions what is needed. Is there somebody cutting the lawn? As far as I knew, there was a gentleman named Gene who used to do it that my grandmother had hired. And I asked for his phone number, and that I was getting ahead of my duties as the executor, that I could maintain a schedule with him, make sure that he's paid, as to not financially burden people who were not appointed as executor. And to maintain, my absolute intention was to, and remains to, protect the assets of my grandmother and her estate through this probate process.
Okay. After you were named executor, was it your intention to transfer the property to the heirs?
My intention was to carry out my grandmother's wishes as she outlines in her will.
Okay. Do you have any questions, Mr. Schwartz?
Nothing further from Ms. Sanders.
Ms. Sanders, with respect
Yes, Your Honor.
the accounts, is there only one account as far
The
as
bank account.
Eden?
The bank accounts, yes.
Is there only one?
There's only one that I'm aware.
And
Well, it's a savings checking account.
it's a what?
And it's a savings and a checking account under one account number that I'm the joint account owner on.
And when you say joint account owner, do you know the formal designation of that account?
Yes,
And
upon survivorship.
it is a joint tenancy with right of survivorship account?
Yes, as far as everything the bank has communicated and information given to me, yes.
Okay. Mr. Schwartz, Ms. Forsyth, do y'all have any understanding with respect to that account being a JTWRS?
Judge, if it were a probate asset, obviously, my client could not have access or get any information of the for the account. But by virtue of her having access to me, shows that it's likely. I haven't seen the paperwork or any of the paperwork showing the actual title to the account. But my client has informed me that yes, it is a survivorship account in which she is the beneficiary of upon the death of of the decedent.
Thank you, Mr. Schwartz. Ms. Forsyth, do you have any?
We are not under the understanding either anyway of how the bank account was titled. We have no information about the bank account.
Okay. Mr. Schwartz, do you have anything further at this time?
Is Joshua Allen on the call?
I am.
Joshua, I just had a few questions that I wanted to ask you. Is that okay?
Please proceed.
Mr. Allen, you've heard the testimony of Miss Abrero, your aunt, and Brittany. You've heard their testimony. Is that correct?
Yes.
And are you also confirming that your grandmother did not revoke her will?
Not to my knowledge, no.
Okay. And is it also your testimony that you are not contesting this will in any way?
No.
Okay, so when I say not contesting it, you're not saying that your grandmother was unduly influenced or didn't have testamentary capacity. You're not saying that. That's not what the argument is today. Is that correct? I'm sorry, can you?
Oh, correct. Sorry.
Okay, good. So Mr. Joshua, so I just want to make sure you, as Brittany and Paula stated in their testimony, your issue is with Crystal being appointed as the independent executor. Is that correct? And you're wanting that term in the will to be nullified, to be set aside, and that Michael be appointed as the executor of the estate.
Correct.
Is that correct? That's accurate? Okay. And that was your purpose of filing your affidavit and being on this call to support that, to support the notion that Crystal should be removed from the terms of this will and should not serve in the capacity as independent executor. Is that correct?
Correct.
And specifically that provision of the will needs to be set aside. Is that correct?
Yes.
Okay, nothing further for Mr. Joshua. Thank you, sir.
Yes, Ms. Forsyth, you may proceed. Do you have any, right?
No, Your Honor, I don't have any more questions.
Okay. Mr. Schwartz, do you have any other witnesses you'd like to call this morning?
No, I don't, Judge.
Okay, this is how we're going to handle closing. Ms. Forsyth, I'm going to let you make your initial arguments, and then Mr. Schwartz, I'm going to let you respond. And then Ms. Forsyth, I'll give you a brief response to his response. And then Mr. Schwartz, I'll let you do the same. And hopefully by that time, we will have exhausted everything that each of you believe you need the court to consider. And then
Okay.
I'll consider the motion.
All right.
Ms. Forsyth, you may proceed.
Thank you, Your Honor. So today we heard many people discuss how the will was talked about, whether it was revoked. Obviously wasn't revoked, but there was some concern prior to the decedent's death that she didn't want Crystal to be her executor, and they had basically a falling out prior to her death. And then from there, we also heard about the current real estate property that the beneficiaries would like to maintain and continue to maintain. However, they've been continually blocked from doing so and told they're not allowed to do so, even though they're in the best position to do so and best area to maintain the property and care for it, as is the wishes of the decedent, who wished for it to go to her children and her grandchildren. From there, we have heard from Ms. Crystal, who has said that she didn't want anybody there because nobody was supposed to be there. We weren't in probate yet. She didn't probate the will, so we had this property that was out there living in a void, if you will, of nobody can touch it, nobody can do anything with it. So Ms. Obrera went ahead and filed the application. However, the concerns of the beneficiaries is that she has not been she will not carry out her fiduciary duty to the estate because she's not allowed them to make necessary repairs, or visit the property, or just even try and visit the property. That is not her intent. Going forward, she states her intent is to transfer the property. However, she's not done that yet, given concerns about COVID. Our concern is that with her not being here and not being able to come to Texas and look at the property, given COVID and her personal illness, that we won't be able to see this move forward in a economical way. We don't want to spend more money for the estate than is necessary, and we want to make sure that the property is maintained and cared for. So it is our argument that Ms. Crystal, after being appointed in prior proceedings earlier today, be removed from the executor position and replace her with Michael Obrera.
Thank you, Ms. Forsyth. Mr. Schwartz?
Judge, Ms. Alvarado should not be removed as the executor of this estate. The main reason being is that this was a choice that the decedent, Ms. Phyllis Saunders, chose to appoint as a third alternate in the event that her husband and her son should perish. They have since died, and Ms. Sanders is not disqualified by law. We've already established that in a prior hearing, that she's not disqualified by law from serving. She has not given her oath yet, so technically she's not even appointed. She hasn't even been appointed. So having this case, it's not even ripe for discussion at this point because she hasn't even filed an oath and hasn't even qualified herself. But even if she did, the Texas Estates Code is very clear for actions that rise to the level of removal of an executor. In her presentation, Ms. Forsyth didn't elaborate on any of the statutory requirements. She did mention the gross mismanagement, I believe, but failed to really develop that. And as such, we believe that there is no statutory grounds for having Crystal removed at this point because she has not had an opportunity to fail. she's not going to fail, but she hasn't, it's purely speculative in them saying that they don't think how she's going to act or what she's not going to do. Now, if once she's appointed, she gets her letters, she files her oath. If there are things that occur, she's on the clock now. And she's aware, she's been advised that after she gets appointed, the fiduciary clock starts now. So everything that she's going to do will be scrutinized by the named beneficiaries as well as this court. And in any event, if she does somehow it becomes derelict in her duties as it pertains to this estate, we will have, I'm sure, a hearing. But in closing, I want to revisit the testimony of Paula Abreu, Brittany, and Joshua, who all stated that they were not contesting the will. Paula herself filed the will for probate, but they all confirmed in testimony, clear before this court, that what they were seeking to do was to set aside the provision in the will that names my client as the executor of this estate. That's what they were seeking to do. And they're fine with all the other terms of the will, but that one provision, for whatever reason, they don't want her to become appointed. They were trying to thwart it before having the hearing on the application for letters. But again, we expressed to the court that Ms. Sanders is qualified and not disqualified. The actions that Ms. Sanders undertook in securing the house, even though she had not been appointed, is no violation of the law to call the cops and say, there appears to be a trespasser that she's not aware of. Could you go and investigate? That's nothing grossly wrong about that. There's nothing that would disqualify her just by virtue of doing that. She's treaded very lightly in terms of handling this. She wants to be compliant with the probate code and with the law in terms of how she's handling this estate, and she's done just that. And in closing, I just want to make sure that I impress upon the court that the application to file probate was filed January 28th. The decedent died December 6th. Application was filed January 28th. On or about February 5th, we filed our notice of appearance as counsel for Ms. Alvarado, and we sought to get a hearing date as soon as possible. It's not common that the person that's not named as the executor files an application for probate of a will. So this was kind of like a uncharted territory as far as moving forward with it. So we sought to get a hearing date as soon as possible to get the ball rolling, because we know that they had demands as it pertains to an accounting and such. But we couldn't do anything, Judge, until Ms. Sanders was appointed. No duty existed. She couldn't get any information as it pertains to the estate. Even if there were bank accounts out there that she may not know about, my client may not know about, that are solely in the name of the decedent, she had no letters testamentary to present to any financial institution to get information to provide to the beneficiaries. So it was very important that we move forward with getting this set for a hearing and getting this before the court to get her appointed so she can execute her duties as the executive of this estate. And as we've stated earlier, there's nothing in the statute that would warrant removal of Crystal at this point. Again, we're having this hearing. I didn't object to it, but at this point, she hasn't even qualified. And as such, Judge, we ask that you consider at least giving her the opportunity to qualify and carry out her duties that her grandmother basically wanted her to do. And the grandmother could have filed a codicil. I know she was wanting to make some changes, but the only way you can make, if she did not revoke the prior will, the only way that she could have made changes is to create a new will or add a codicil to the existing will, updating who she wanted to serve as the executor. But none of that occurred. And the witnesses themselves have all testified that the grandmother did not revoke the will. So as such, it would be against policy to allow them to basically nullify a provision of the will, which under paragraph 9 is sufficient to disinherit them from this estate, because it clearly states that if anybody starts any proceeding to set aside any provision of this will, they will be disinherited. And that's exactly what they've done. Their testimony has confirmed that. They've all, Paula has stated it, Joshua has stated it, and Brittany has stated it. They've all filed on testimony on the record stating that what they're seeking to do is what the decedent clearly stated in her will that she did not want to do. If they did that, they would be disinherited. So that's another issue. But as it stands today, I think that the judge, hopefully you will not remove my client, Crystal Sanders, and allow her to fulfill her duties as the independent executor of this estate.
Thank you, Mr. Schwartz. Ms. Forsyth, do you have any rebuttal?
Yeah, absolutely, Your Honor. So I did want to touch on a couple of things that Mr. Schwartz mentioned. So Texas case law does state that an executor can be removed for gross misconduct or gross mismanagement. Under that, that's the estate of Miller, 243 SW3D 84041. And it's just at this point, I mean, there should be no reason for us to have to monitor, or the heirs to have to monitor, an independent executor to make sure she's doing what she's supposed to. Also, to Mr. Schwartz's point about we're seeking to change the will, that's not true. I think they misunderstood the question. We are seeking to remove her. So we went ahead in this proceeding today and made Miss Crystal the executor, and we originally did that. And then our point is that we want to remove her as executor. We do not, that is not, I understand where you were leading the witnesses, and I apologize. I probably should have objected, but I tried to clarify that with them. And I think that's just a gross misunderstanding on their part of how the system works and what the words that were being used to make that happen. And also kind of a little sneaky on their part. It's the will is the way it is. We've established that she didn't revoke her will, that she didn't tear it up. She kept it the way it was. The only thing is that they tried to work with Crystal. Crystal didn't want to work with them. And now they're seeking to remove her to make sure that their grandmother and mother's wishes are done as the will states. Thank you, Your Honor.
Thank you, Mr. Schwartz.
And Judge, just for clarification purposes, when we scheduled this hearing, it was the position of Ms. Forsyth that she wanted to have her removed before we had the application, before we heard the application for probate of the will. So it was from Jump Street, they were seeking to remove Crystal from the picture. In our communications with your staff in terms of setting the matter for a hearing, we stated clearly we should have the hearing on the application first, because you can't remove an executor who hasn't been appointed. The representative of Ms. Forsyth's law firm said, no, we want to have our motion heard first. So it was obviously clear that they wanted to have Crystal taken out of the will altogether. And that was their purpose, to have her removed from this will and have her basically have that provision essentially canceled out. And I think that there was no deception. There was no sneakiness in terms of what we were asking. Maybe they weren't aware of it, but there was nothing deceptive about what we asked as it pertains to having Crystal, that provision in the will, set aside, appointing her the executor. That's why we're here. The record is clear on that. The pleadings are clear. The affidavits are clear. The motion is clear. All that is clear. So there's no dispute on that. That's all part of the record.
Thank you, Mr. Schwartz. Ms. Forsyth, I'll give you the last shot. You got anything else?
Thank you, Your Honor. So I think that was just a scheduling error between my office and your office, and trying to coordinate with the court. There was no, my understanding was we were going to do it all together. That was what our intention was to do it all together at one shot. That's all.
Okay, thank you guys very, very much. Before I issue my ruling, I'd like all the family to hear me. And you're not going to want to hear what I have to say. But I want you guys to understand that I too am a lawyer. I've been licensed since 2005. I've practiced probate in B County and the surrounding counties since 2010. I've had the displeasure of representing grandchildren against grandparents, fathers against children, siblings against each other, and every other iteration in between. What I've seen today and what I've heard today and see in the file in this particular case is unfortunately not unique. Oftentimes when a matriarch or a patriarch pass away, the wounds of the past come to the forefront. And I don't think this is what the decedent would have wanted. And I could be wrong, and you don't have to agree with me. And that's okay. But if I were to provide y'all with any direction at all, I would encourage you to really think about and consider the fact that your mother, your grandmother, made this will, and for whatever reason created now an opportunity for y'all to reconcile and have closure with each other, so that when this process is over, hopefully there will be at least no ill will moving forward. And that's a tall order. But I think if you guys are sitting by yourself late at night without the benefit of being on a funky Zoom call, without having to answer these questions in an adversarial manner, that ultimately it'd be best for the memory of your family and your grandmother and mother to find a path forward, to find a solution. Fortunately for both of y'all, as has been exhibited this morning, each of you have fine lawyers that represent you. The court has no doubt that Mr. Schwartz and Ms. Forsythe have a very strong working knowledge of the Texas Estates Code, of the preferences that the state legislature has made with respect to opportunities for resolving family disputes such as this. But the simple fact remains that there is no testimony that I've heard today. There is no factual statement contained in your affidavits that support removal at this point in time. And you may not like to hear that as an independent executor, Ms. Sanders Alvarado will operate mostly independently from court oversight and supervision. You do have recourse as beneficiaries, and Ms. Forsythe is very aware of those. And that would be the initial impetus in the filing of the motion, is that you as the beneficiaries now have received, or Ms. Sanders Alvarado, upon her qualification, will have fiduciary duties that she has that benefit y'all. So that y'all know that the court understands basic estate law. The duties of an independent executor are to collect the assets of the estate, to pay the debts of the estate, and to distribute the remaining assets, if any, in accordance with the terms of the estate. The state legislature encourages families that are fighting to find a way to resolve their dispute through the use of family settlement agreements. This is a real dispute, and it would probably be in the best interest of the family to at least make an effort to resolve your dispute amicably. There may never be any ability for Ms. Sanders Alvarado on the one hand and the Abreros and the Sanders on the other hand to trust each other ever again. But a lack of trust without some factual evidence to support and show while fiduciary duties existed, gross mismanagement, embezzlement, and the other components of Texas Estates Code chapter, is it 401 or 3?
It's 361.
Of 361, the court has no ability to grant a motion to remove Ms. Sanders Alvarado as executrix of the estate at this time. And I know that Ms. Forsyth, when we get off this Zoom call, that she'll let y'all know the next steps, the next obligations and requirements that are imposed on Ms. Sanders Alvarado under the laws of the state of Texas, as I am confident that Mr. Schwartz will make sure that Ms. Sanders Alvarado understands what her obligations are moving forward as well. It would seem to the court that that there could be a manner for the family to work together to get this done in an efficient manner. But the court will caution all members of the family that the guiding light from the Texas legislature with respect to allowing a family to recraft terms of a will by agreement to avoid a dispute is merely an acknowledgement that if families aren't afforded that ability to resolve their fundamental issues by changing the terms of the will, then all of the estates of the decedent will go to the lawyers. And nobody wants that. Okay? So, Ms. Sanders Alvarado, you have a lot of work to do, and you have beneficiaries who are unhappy and untrustworthy or untrusting of you. My apologies. And are eager to see that this will is carried out. And to the beneficiaries, you cannot rush the executrix. The executrix has statutory timelines in which she can execute her duties and her obligations. And this court trusts that if the executrix makes any missteps at any point in time, that it will receive additional filings to bring those to light. With respect to future hearings, I apologize. This one I wanted to set earlier, but just as a part, we are a small county. I have a very small crew, and COVID really isn't a problem for us anymore, except for the whole Zoom thing. But we've had a couple other issues that have really taken a lot of free time for the court. So I apologize on the delay, and nobody I know is complaining about that, but I do want to let y'all know that we try, and Mr. Loya, who Ms. Forsyth and Mr. Schwartz have communicated with as well, we try to be quick and responsive. We set hearings. If the parties can agree, we'll set them whenever I'm available. And we can continue to hold hearings as long as the Office of Court Administration allows us to utilize Zoom, which simplifies the process. We will be returning to in-person hearings beginning in April, but again, we can appear remotely. That's fine with me. I would prefer not to have to hear any more matters on this case, because both sides, even if they can't get along, even if they can't find a path forward, they go on to get on. But with respect to the motion that's pending before the court at this time, the motion is denied. Is there any further discussion that we need to have or comments at this time from either attorney?
No, I'm all set, Judge. Thank you.
No, thank you, Judge.
Nothing here.
Thank
you, Mr. Schwartz, for your time.
Okay.
Y'all are all excused. I wish you